Namaste and greetings. I, Nikita Bhardwaj, researcher at IMPRI, Impact and Policy Research Institute, Prabhav एवं नीति अनुसंधान संस्थान नई दिल्ली, extend my warmest welcome to you all to IMPRI #Web Policy Learning. Today we are gathered here for Day 22 of Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course and internship program. This program is organized by IMPRI, Impact and Policy Research Institute, New Delhi. The chair for the program is Professor Vibhuti Patel, visiting distinguished professor at IMPRI, and the fellowship lead advisor and expert legal hands-on sessions is Advocate Dr. Shalu Nigam, visiting senior fellow IMPRI. The distinguished experts includes Shri Sandeep Chachra, Professor Vibhuti Patel, Advocate Dr. Shalu Nigam, Advocate Dr. Vaida Nainar, Professor Mukul Ashar, Professor Uday Shankar, Shri Udit Mishra, Dr. Nivedita P. Haran, Shri Bhartendra Singh Baswan, Dr. Purnima Chauhan, Advocate Dr. Albertina Almeida, Dr. Gladstone Xavier, Professor Aruna Roy, Advocate Audrey de Mello, Dr. Kaustav K. Bandyopadhyay, Advocate Mrinalini Deshmukh, Professor Sharmila Ghoge, Advocate Flavia Agnes, Dr. Rashmi Singh, Mr. Devaditya Sinha, Professor Swaran Singh, Advocate Lara Jasani, Professor Anil K. Gupta, Justice Ajit K. Singh, Mr. Himanshu Shekhar, Dr. Amar Jasani, Dr. Soumyadeep Chattopadhyay, Mr. Bilal Khan, Shri Rajiv Ranjan Singh, Shri Tikender Singh Panwar, Shri Shailesh Gandhi, Dr. Simi Mehta, Advocate Abdul Hafiz Gandhi, Professor Amita Singh, Dr. Ajay Gudavarti, Shri Amit Dubey, Professor Sanghamitra Acharya, Dr. Y. Suresh Reddy, Advocate Sanchita N. and Shri Surendranath Tripathi. The conveners for this course are Dr. Simi Mehta, CEO and Editorial Director at IMPRI, Advocate Dr. Shalu Nigam, Visiting Senior Fellow IMPRI, and Dr. Arjun Kumar, Director at IMPRI. I welcome you all to this enlightening deliberation and thank you for putting your time, energy, and efforts into truly understanding the vital role and complex intricacies of legal and public policy frameworks. This course will enable the participants to comprehend the nuances and technicalities of legal and public policy paradigms, and therefore acquire theoretical insights along with technical skills to conduct research. We have also shared the course outline and reading resources document in your email for your kind perusal. We will be providing videos of each session for flexible learning at your pace and place. Before we start today's session, I would like to announce the housekeeping rules. It is imperative that you join the meeting on time. There will be a Q&A session after each presentation. Share your questions in the Q&A box and not in the chat box. The questions must not be posted as an anonymous attendee. Ensure that your questions are precise. Refrain from making general comments in the question to save time. Our session for Day 22 will cover topics of Legal Hands-on Session 6 by Advocate Dr. Shalu Nigam, a review of the RTI Act by Advocate Abdul Hafiz Gandhi, The Politics of Law and Deficits of Implementation by Professor Amita Singh. To start the session, I would like to invite Professor Vibhuti Patel for her opening chair remarks.
Thank you, Nikita, first of all, I would like to thank the IMPRI team, Dr. Arjun Kumar, Dr. Simi Mehta, Dr. Shalu Nigam, Ms. Sweta Shankar, Mr. Satyam Tripathi, Ms. Nikita Bharadwaj, and I welcome Dr. Advocate Abdul Hafiz and Professor Amita Singh and the esteemed participants. We all know that we are in the 8th week of this course, and we have already understood and deliberated upon the relationship of law and public policy, international human rights instruments, functioning of Indian judiciary and bureaucracy, the rules of governance, functioning of Panchayati Raj institutions, challenges of urban governance, and the role of civil society in shaping of laws and public policies, and also the impact of public policies and laws on the civil society. That's a two-way relationship. We have also gone through the gender aspect and the gender responsiveness of laws and public policies, and exhaustive sessions were there about the environmental policy, forest law, the people's participation in shaping the policies regarding social sector budgeting and the right to education, right to employment, right to income support, and also the housing rights of the people. And also we have had a series of interactive sessions which also enhanced our confidence, and we also had sessions on research methodology, method of data collection, data analysis, data cleaning, quantitative and qualitative research, their strengths. And the sessions with Dr. Shalu Nigam were very good because they also participants had a scope to intervene and come up with their own understanding, and also critically reflect on some of the mind-boggling issues. So now today we are going to have if we start with the interactive session, and we are going to have equally interesting sessions on the review of RTI, because RTI, previous 2 sessions when Dr. Aruna Roy, Advocate Nikhil Day, and Mr. Shailesh Gandhi, they all also mentioned RTI and its strength. And now there is a review because RTI was put into place in 2005, and now we have had nearly more than 1.5 decades of experience. And also the law, policies, and administrative reform. There is a major discussion going on about administrative reforms, where the slogan that is that list government, governmentality, and the maximum governance. So minimum governmentality and government, and maximum governance. So that is the motto recently, where all the global leaders have been talking about it. So we are going to have very interesting sessions today. Thank you.
Thank you, ma'am. Next up, I would like to invite Advocate Dr. Shalu Nigam, who will be taking up the legal hands-on session 6. Advocate Dr. Shalu Nigam, visiting Senior Fellow IMPRI, Advocate, Author and Researcher, Gender and Human Rights. Welcome, ma'am, and over to you.
Thank you, Nikita. So today we'll be talking about access to equal justice and free legal aid. Last time we, is this visible?
Yes, ma'am, it's visible.
So in the last session, Mr. Gandhi, he talked about justice, delayed is no justice at all. So today we will look at the other aspect of justice, which is about, free legal aid and how equal justice could be provided. So there are international provisions relating to access to justice. For example, the UN Principle and Guidelines on Access to Legal Aid in Criminal Justice System, 2013. It talks about legal aid as an essential element of fair, human, and efficient system based on rule of law, and this includes right to fair trial. Similarly, the Sustainable Development Goal 16, which is about peace, justice, and institution, and is committed to build effective, accountable, and inclusive institutions at all levels by year 2030. This is something, a quote which is by one of the famous, pioneer of the legal movement in USA, and he, in his book, Justice and the Poor, he wrote that without equal access to the law, the system not only robs the poor of their only protection, but it places in the hand of their oppressors the most powerful and ruthless weapon ever invented. So he is talking about, the justice, if the poor are being denied justice, they could suffer, be victimized by the justice system. So when we talk about legal aid, so it is central to providing access to justice and ensure equality before the law, the right to get the legal advice, and right to fair trial. So it is a vital function of the welfare state, and in countries all over the world, we have the system of pro bono lawyers. Pro bono lawyers meaning the lawyers who are working on their own, on their voluntary thing. They're providing help to people who can't afford lawyers. Then there are NGOs and paralegals. Then we have state-funded legal aid centers, and we also have legal aid clinics. legal aid meanings, meaning when the university or the law university or law department in any university, they take up the kind of, they can the nearby community they can take up, and then they can visit that community. The students can go there and can have first-hand experience, and they also help the litigants who are there. So if we talk about India, in India we have Article 39A of the Indian Constitution, which talks about equal justice and free legal aid. It says that the state shall secure the operation of the legal system which promote justice on basis of equal opportunity, provides free legal aid by suitable laws and schemes, so as to ensure opportunity for securing justice, so that justice is not denied to any citizens by the reasons of economic or other disabilities. It was inserted in the Constitution by 42nd Amendment Act in 1976. So free legal aid, therefore, is a constitutional provision. The citizens have right to free access to legal process without any discrimination on account of class, sex, race, creed, or the economic affordability. It means that legal service should be made available to the weaker sections of society. It also enacts the full opportunity to be given to women, children, elderly, and persons with disability. And the provision is aimed at ensuring access to justice for all. So it recognizes that the cost of legal proceedings can be a major barrier to the justice, and it seeks to remove this obstacle by providing free legal aid. So why do we need this special provision? It's because when the Constitution came into force, somehow this was not added, but we have to realize, as the welfare state, India has to realize the goal of providing legal aid to all, to provide justice to all. So it is seen as a part of a process rather than an end in itself. The objective is to afford equal justice and equal opportunity to all, and it is a prerequisite for any meaningful redress of grievances. So when any person is denied legal aid, the complaint remains unheard, and therefore the justice itself, the object remains futile. So if we look at the historical development, we will see that the report of Law Commission of India on Legal Aid, which was submitted in 1956, it says that legal aid is to be provided to the poor and marginalized sections who were unable to access justice due to their inability to pay for legal services. And in 1973, the Supreme Court, in a landmark judgment in Husainara Khatun versus State of Bihar, it says that right to free legal aid is an integral part of the right to life and personal liberty under Article 21 of the Constitution. When we talk about right to life, so it is a part of right to life. This judgment emphasized the need for legal aid to be provided to all persons who are unable to afford it, and it calls for establishment of legal aid committees at district and taluk level. Then after that, we have several of the judgments where the Supreme Court had said that right to legal aid is an essential element to the right to fair trial, and the state has duty to provide legal aid to those who cannot afford it. It says that legal aid should not be restricted only to certain stage of trial, but it should be continuously provided till the aim of justice is reached. And in NC Mehta versus Union of India, it says that the state has a duty to provide legal aid, and it cannot be restricted only to criminal cases, but should also be available in civil cases, and especially to those who are poor and marginalized. So basically, the praxis function of the legal aid system is to reduce the pre-trial incarceration, the number of wrongful conviction, re-victimization, and number of cases of custodial violence. So it is crucial to individual right to a fair trial. So in 1987, we enacted Legal Service Authority Act. This act was enacted by the Parliament, and the word service itself indicate that it is not merely a voluntary help, but it is an obligation of the state to provide legal service to the poor, illiterate, and ignorant person. And it also sets the limit, the income limit. So any person whose annual income is less than rupees 5 lakhs, in case of, in respect of case filed before the Supreme Court, he or she will be entitled to legal services. In Tamil Nadu High Court, they have fixed this income limit to rupees 3 lakhs. So various states have made different provisions. So basically, this right is available to those who require it to help litigants in person. In case if if I am a person from who doesn't fit into this category, so and I want to file a case and I want to file a case on my own, so the court may appoint a friendly lawyer who can assist me. So it may not provide me free legal aid, but then the lawyer is appointed as the friend of the court to arrive at the justice. So Supreme Court has clarified that it is not obligatory for the state to provide free legal aid in all matters, and it all would depends on various rules and other things. So we have various authorities which are established and working under the Legal Service Authority Act. So these are National Legal Service Authority, which is working at the national level. In states, we have state legal service authorities. At the district level also, we have district legal service authorities. In Supreme Court, we have Supreme Court Legal Service Committee, High Court Legal Service Committee, and Taluk Legal Service Committee. So these are the various levels at which this authority is working, and it mandates the government to create, to provide legal aid to all, and the committees, the National Legal Service Authority is one which is assisting other states to establish the Legal Service Committee at the state level. So these are the functions of the Legal Service Authority. So it is basically the legal literacy programs, creating legal awareness programs, giving legal advice, providing legal aid to weaker sections, deciding the victim compensation schemes, resolving dispute without going into trial. So we can have mediation and conciliation, and also the lok adalats, which is settlement through conciliation. So how can one apply for legal aid? A person can approach to the concerned authority through a written application, and the person has to state the reason for seeking legal aid, and the person has to give his or her income certificate and all other formalities to be completed. So the application can be filled online also. And for different sections, we have various schemes. So we have schemes for differently able children, which came in 2021. We have special schemes for senior citizens, for the victim of acid attacks. We have schemes for victims of trafficking and commercial sexual exploitation. We have schemes for workers in unorganized sector, and special schemes for mentally ill and mentally disabled persons. Then we also have protection and enforcement for tribal rights, and for victims of drug abuse and eradication of drug menace scheme. So you can just go to the website and look into the schemes. And then we have the lok adalats. So lok adalats is considered as one of the substitute or as an alternate dispute redressal mechanism that is called ADR. So it works along with National Legal Service Authority, and it is a forum where case or disputes which are incomplete in the court of law, they can be compromised in an amicable manner. So the composition of lok adalat is, we have a chairman, 2 members, and 1 social workers. The chairman must be a sitting or a retired judicial officer. The other 2 members should be lawyers. And so under this Legal Service Authority Act, lok adalat have been given statutory status, and their final award which is being given is considered to be a verdict of civil court and ultimately binding on both the parties. So basically, how it works, it provides resolution through amicable manner, and both the parties have to be ready that they are ready to compromise the matter, and the members shall assist the party in an impartial manner to reach a cordial settlement of the dispute. So there is no provision of appeal against the verdict made by the lok adalat, and if the parties are not satisfied with the award, with the decision, they can. There is no provision for appeal, but they are free to initiate litigation. And there is no court fee payable when a dispute is filed in Lok Adalat. And even if dispute is pending in the court of law and it is referred to Lok Adalat and it is being settled, so the court fee originally paid in the court will be reimbursed back to the parties. So as we have spoken earlier about the pendency of cases, and so many cases are being pending at various level in High Court, the Supreme Court, and also at the district level. So it is seen as an important mechanism where litigants can approach Lok Adalats because it is a party-driven process, and it is being said that Lok Adalats have helped to reduce the pendency of cases. The data provided by National Legal Services Authority says that more than 15.14 lakhs Lok Adalats organized across the country as of 2015, and more than 8.25 crore cases have been settled by this mechanism so far. So the benefits of Lok Adalats are that it offers speedy settlement of the cases, and cases can be disposed of in a single day. There is no strict application of procedural laws, as we have seen, how the laws, Indian evidence, you have to give evidence, you have to go through the procedure. So Lok Adalats are very fast due to flexibility. The awards issued by Lok Adalats are, it's due to joint compromise petition, which has the status of civil court decree, and there is no court fee. But there are certain limitations. For example, in many of the cases, litigants are pitted against the entities who can invest resources, those who are elite or rich. For example, there are many cases of electricity boards, insurance company, banks, where compromise are being imposed on poor. They have no choices but to accept them. So because compromise is the central idea of the system, so there is a concern that while speedily disposing of the case, the idea of justice could be undermined. And in various cases, the court have said that the Lok Adalat is purely conciliatory and it has no adjudicatory or judicial function. So, that way, if the parties are not at par, there could be a problem in terms of justice. So, but when we see the other things which are related to legal aid, so if we see the data, as of March 2022, India has 50,000 free legal aid service providers. So it means one legal aid lawyer per 18,600 population, or 5 legal aid lawyers per 1 lakh of population. Maharashtra has highest number of legal aid lawyers and Mizoram has the least. A study by High Court of Odisha, it shows that majority of funds are utilized for administrative services rather than the legal aid itself. As per the 2018 Commonwealth Human Rights Initiative, they conducted a study and they found out that the per capita spending on legal aid in India is only rupees 0.75 per litigant, which is one of the lowest in the world. The Tata Trust India Justice Report in 2019 and 20, it says that per capita spending in legal aid is in India was only rupees 1.05. So the India Justice Report 2022, it says that there are 4 pillars of justice delivery: the police, judiciary, prison, and legal aid. And they analyze each pillar in terms of budget, human resources, infrastructure, and other things. So they found that the national per capita spending on police in 2017 and 18, it was rupees 912, and it increased to rupees 1151 in 2020 and 21. The budget for legal aid clinic is reduced by 44% between 2019 to 2021. Delhi and Chandigarh, except for these 2 union territories, no state spend more than 1% of its total annual expenditure on the judiciary. Most states have not utilized the funds given to them, and the judiciary, the police and prison, they all require investment, but most of the states are not utilizing those funds. So spending per inmates in terms, when we talk about prison, so there are inmates in the prison, And the report says that the spending per inmate, which includes the cost of expenses of food, clothing, medical needs, vocational training, educational and welfare activities. So this budget for prisons in 21 and 22, it was 7,619 crore, and only 88% of this budget is utilized. Of this, 31% was spent on food, clothing, medical needs, and other activities. And 16 states and 48 union territories spent less than 35,000 on inmates annually, or less than rupees 100 per day. So this is the condition of prison, that the spending per inmate in terms of the provision, it is less than 100 per day. When we talk about the police stations, the number of police stations, so we have 17,500 police stations to serve population of 1.3 billions, and the area of so many square kilometers. So roughly there is one police station for 78,000 people, which is covering the area of 187 square kilometers. The National Police Commission 1981 recommends that for 150 square kilometer in a rural area, we should have one police station. So we are running back behind in this process. Then prisons are overcrowded. The model prison manual 16 requires that one doctor should be available for every 300 prisoners, but there is a chronic shortage of qualified doctors, and we have only the sanctioned vacancies are not filled. So we have 3,497 sanctioned vacancies, and we have only 2,000 personnel who are working there. So and in Goa, this vacancy is up to more than 40%. So in April 2022, the former Supreme Court Judge Justice Lalit E, during a lecture, says that a legal aid to the poor does not mean poor legal aid. There has to be better standards, better quality, and better level of services. So what are the suggestions which have been given to improve the services, the free legal aid services, as well as improving the infrastructure and spending in terms of police, prison, judiciary, and legal aid? There is also need to involve law schools in justice delivery process. In United Kingdom and also in United States, when I visited there, I have seen their clinical legal education program, and they work, the universities, the law schools, they work in association, they adopt a community nearby, and they work with NGOs and other civil society organizations to improve this legal system, the infrastructure and services. So in the United Kingdom, for instance, the study revealed that the legal clinic handle the average of 104 cases per year. So the per capita spending and the budget has also to be increased. Then we can also work in collaboration with the companies. The corporate social responsibility funds could be utilized towards legal aid, and the compensation which the legal aid lawyers get is very low in terms of and if you compare a lawyer who is getting the senior lawyers who are giving who are getting thousands, lakhs and crores for one appearance, but if you compare, that is very less for the legal aid lawyers. So, and mostly this payment is delayed, and there are a lot of other problems which the lawyers have shared. So in the India Justice Report, it has suggested to enhance the infrastructure in the court, the police station in rural areas, and to increase the number of legal aid clinics to reduce the disparity in access in justice. Then, prioritizing the availability of trained lawyers and paralegal across poorly served area. That is another suggestion being given. So allocation of spending of budget is another area that needs to be critically examined. So another suggestion is that we can have innovative ideas in terms of strengthening the services, in terms of legal awareness, legal empowerment, capacity building, judicial advocacy, speed, and quality of justice. so Justice P.N. Bhagwati, and with this court, that the court has to innovate new methods and strategies to provide access to justice to large masses of people who are denied basic human rights, to whom freedom and liberty has no meaning. So I will end with this, and we can take questions if they're there.
Thank you so much, ma'am, for such an erudite and insightful session. I would like to request Professor Vibhuti Patel to share her remarks. Ma'am, please unmute.
Free
yourself.
legal aid is very important in a country where majority of population cannot afford. Neither do they have like bigger networks to reach out to the lawyers who would be empathetic to their tragedy, and nor do they have money. So I think free legal aid is very important, and Justice Bhagwati, who played a very important role in those days of a very active role of judiciary during the 80s that it came, and so many survivors of domestic violence or dowry or sexual violence or ill treatment by the authorities or the vested interest to the poor workers and peasants and forest dwellers and tribal, they benefited. So I think it all began with a very what you call sympathetic environment, that you create a non-threatening environment, and then the people would open up and they will tell what kind of just injustices is meted out to them. So I think main thing is that the legal professionals who are supposed to defend their rights, I think their motivation plays very, very important role. And she said the type of legal services, pro bono lawyers or the NGOs, paralegal courses, because during 80s, we know that so many universities and colleges had also started paralegal program where citizens lawyers or even you as a citizen could fight the cases, no? So though that type of thing. Plus, when the question of Lok Adalat, I think Lok Adalat have been used widely by the social movements. They have approached Lok Adalat because the members who sit there on the jury, they speak local language, they know the local culture, and they also give a very democratic space to the people, aggrieved party, to put forward their program. I have been the member of jury of several Lok Adalats of the informal sector workers, domestic workers, survivors of the communal violence in Gujarat, or survivors of the domestic violence and dowry. One knows that the atmosphere when you go to a court, the intimidation with the aggrieved party would face, that you don't see. There is a far more empathetic environment. So I think that whole culture of Lok Adalat, which is now currently we don't see so much of it because everything is so much individual. The whole neoliberal logic has also seeped into the legal profession. And we don't get this kind of commitment in city like Mumbai. You would hardly get a lawyer who is ready to take up social issues. Everyone is interested in the intellectual property. Even if you see the law courses, the courses which are people oriented, in that you would find less number of students. So I think that mindset also will have to be changed, that social orientation, you use your knowledge, not just to make money, but you use your knowledge, legal acumen for the justice and also creation of equality. Another thing is that the question of whole conciliatory approach in Lok Adalat, we have seen wherever the Lok Adalats have been. So ideology of people who are giving justice, dispensing justice is very important. We have also seen a Lok Adalat in several northeastern states where a rape victim was asked to marry the rapist. And there were people, they very vociferously defended that. And imagine the trauma of that girl who is supposed to live with the abuser, and that abuse, she would face even more abuse because she has made this issue public. She went to the Lok Adalat and told that this man had abused me. We have also seen that after conciliation, when the girls have been sent back to their in-laws, what they say is only the dead body. Okay, so that is also how conciliation by any means can be extremely detrimental to the people who are at the receiving end of the system and receiving end of the power relation. So I think it's a very important to understand that, okay, we don't want conciliation by getting rid of the person who is less powerful, okay, or at the loss of their cost of their life. That should not happen. So I think it is a double-edged. It is an important way, because as compared to the intimidating environment where lawyers from both the sides are screaming and using all mystified language, as compared to that, Lok Adalat are good. But there also the ideology of people who are dispensing justice becomes very important. So finally, we come back to the legal awareness and also the question of what kind of the justice and whose side you take. So finally, it revolves around that. And that's why you can see that your power to argue, to your logical way of putting things and winning over points, that alone is not important. Whose side you are with? No? Who are you with? The people who are exploited, oppressed, facing degradation, injustice, dehumanization, exclusion. Are you in their side? There are several films on it. Court is a very good film, award-winning film. You can see that how things are happening in this thing, no, where a Dalit Shire, he has been incarcerated. He's nothing, he's just only singing songs of Baba Saheb Ambedkar, and for how long he's incarcerated, and how the different legal system, whether it's Sessions Court or High Court, operates, no? So, he being a Dalit and Anti-Atrocity Act and also, even the legal aid system doesn't help. Even if you must have seen Vijay Tendulkar's film Akrosh, where a tribal woman was gang raped, and they are entitled to legal aid service. But what kind of defense that person, her husband, who is supposed to be the murderer, gets from the legal aid service? So I think these are some of the mind-boggling issues, but we still need to bank the system and make it more empathetic to the people who come from the underserved sections of society. Thank you.
Thank you, ma'am. Moving on to the question round. Garvit Gupta, please unmute yourself and ask your question. Garvit, are you there?
His raised hand.
Meanwhile, if anyone else has any questions, please raise your hand.
Garbita Gupta, Amit Roy.
Hello, am I audible?
Yes, you are.
I'm really sorry, I was having some network issues. I think that's why I was not able to respond or hear you people. Do you mind if I ask my question?
Yes.
Yeah, please go ahead.
With respect to the legal aid, the intent of the legal aid is basically, I suppose, relieve individuals, especially those who are at threat and marginalized, of the sheer violence that the judiciary may often pose towards them, because they do not themselves have the legal power or access to legal services. So I had a question on towards the same intent. Would you say that decriminalization of certain crimes and offenses, minor crimes and offenses, misdemeanors, and offenses that may be born out of socioeconomic vulnerability, would you think that would also lead to a similar goal, say protecting people from crimes which they should not be really held responsible for all the time? Like, I'm sorry, I think I'm not being very clear, but I guess if that makes sense, I'll clarify in a minute if required.
No, it's okay, I get it. What you are asking is that that there are people who may commit crime, maybe out of necessity. So because if someone is stealing a bread because he or she wants to feed the starving children, the children are dying because of starvation and all, and if somebody is stealing a bread, the father or the mother is stealing a bread, so should it be considered as a crime? And should it, what kind of things we can do in that situation? Should this person be criminalized, or should this person be be punished? So in that kind of situations, we really need to have a kind of moral understanding, a kind of, it may not be entirely the legal thing, but it also the moral and the social kind of consciousness which we must have as lawyers and judges. So can this person should be imprisoned just because of this crime, because the society, I think it's more responsible for making this family to come to the stage of starvation. So in that case, it all depends on you. But yeah, that should be done. And ideally, should be done that the family should be given help. But our legal systems are the consciousness we have to that generate that kind of consciousness, the kind of sensitivity we have as lawyers and judges. So basically, but in India, if you see that a lot of prisons, the kind of people who are there in prisons, they are basically, who are they? Basically, they are poor people because they cannot afford lawyers, because they cannot have resources. So again, we have to really think about the whole situation which is there. And especially in cases of women, we have seen the Maya Tyagi case. Ma'am may remember that how that rickshawala and her wife was raped, and then she was labeled as whore by the police. Yeah, so ma'am can elaborate on that. So
Yeah.
so that those kind of judgments are there where the poor people are being tortured by police, the poor people are being treated very badly by police. So these kind of things are there. So I don't know, we have to work more on in terms of sensitivity, in terms of that developing that kind of consciousness. I don't know how to develop that kind of consciousness where you are more prone to pro people kind of approach. So
Yeah.
that is, I think, we need to work on. So yeah, gender sensitization and how to increase this kind of sensitivity, that is, I think, more important. So ma'am can really add about.
Yeah. Garvit, you asked an excellent question, very, very important, because of the criminalization of tribal women that happens. And I think it has been a theme of so many short stories and novels and films and documentaries. Just they enter the forest, in which they have lived for generations, and they take some, and there are some 900 types of non-timber forest produce, which they collect, and then they give it to the either pharma industry or whosoever. So for that, people's movement had to struggle for nearly 3 decades to decriminalize the tribal people and connect them with because if a Irula tribe, the most powerless tribe of Tamil Nadu, okay, so Irula tribe, they catch baby crocodile, for which they get 2 rupees per crocodile by the pharma industry. They catch snakes, they get 8 annas for that. They catch frog, they get 10 paise. And the forest official would call them thieves. Leave aside this kind of a produce, but at the same time, like they also take dry leaves and dry barks of the dead trees. But they say that they are felling the tree. So this kind of accusations are made, and that is used for burning of tribal bastis, then mass rape of tribal women. If you see the investigation reports of civil liberties and democratic rights organization throughout the 70s and 80s, these are the kind of reports there. So your question is very important, that when it comes to the petty economic crime can't be this. There is a very good serial, I think, in English, where they show, American serial, where they show that she did not she just took the loaf of bread. The child was very hungry, and then that child is incarcerated. And this asked that what? This, no, I had not eaten for 3 days. So the judge punishes the shopkeeper, that instead of giving her 2 loaves, why have you punished this child? Don't you know that hungry child has to be fed? You are making enough profit. So that kind of thing. Then other time, like when the collective responsibility, a woman who is incarcerated by the police, the judge said that she has lost her wages for 5 days. And I tell every member in the court to shell out $10 each. I'm the first one to give, because it's a collective responsibility of being so insensitive to a person who has not committed crime, or maybe according to you, broken some rule or jumped the queue or whatever. Because they use the loo, so there you have to pay, and then you can use the public toilet. Now this lady, she jumped and she used the toilet, and then she was arrested because they have all the monitoring system. So I think it's a very important question, because it is all sense of social justice that you have. that certain thing is stealing of bread or stealing of food is stealing, first of all. That question we have to ask. There was a time where children of the poor people, they were punished for and given corporal punishment for stealing book. What did we demand? We said, why should they should not get book? Every child under Sarva Shiksha Abhiyan should not only get book, but shoes and uniform and hot meal and free transport. That child is traveling ticketless, and that's why you would catch hold of it. Why? First of all, we want every child to get education. So these are some systemic solutions we need to bring. Individually, decriminalization is yes, but wherever there is a deprivation and a complete exclusion from any developmental investment, then we need to do both the things. First of all, decriminalization of individuals who are incarcerated, and at the same time, systemic solutions, systems and structures we need to change. That instead of accusing this child of stealing a book or stealing a pencil or eraser, I know though in my times such kind of punishments were given to a poor child, because you always had a 1 or 2 free ship child, and all other children would have everything excellent, and this child would not have. Suppose one day he took the eraser, why should the child be punished and called a thief? You can't label a child like that, no? And from this kind of anger, that the whole movement, which Anita Rampal and Anil Sadgopal, that the whole question of RT, right to education, which is the right of each and every child in India. And education cannot be just given by the lectures. You need to provide full support system for that. And that's how the idea of taking professional tax, like 2% at source from every working person in India, which supports the EGS kitty. Employment, not a EGS kitty, but that is in Maharashtra. But this is for Sarva Shiksha Abhiyan. All of us are paying 2 rupees, 2% of our salary for Sarva Shiksha Abhiyan. And nobody is grumbling. So that way, Indian population has become mature. They are not the type like earlier. They would say, why should we pay for the poor children? This thing, that kind of response has not come. So that maturity as a population, as a country, we have arrived at that. Yes, these are the basic things which every child should have in a country. So both individual solution and systemic and structural changes, both we need to have.
Professor, I'm sorry, just a little follow-up. So, I think Professor Shalu Nigam mentioned something about we have to develop a certain moral and political consciousness on whether we should hold these people responsible or not. I don't really understand how we can override years and decades of social conditioning where people are supposed to hate others who are not successful, who are below them in class, caste, gender, and so on and so forth. I think I should have asked actually more accurate, which I did not ask, it's my fault, is how can we, in a way, as you mentioned at the end, Professor, how can we make this a systemic change, especially in the legal framework? Because we cannot say rest on the judgment or the consciousness of the individual judge, the prosecutor, or some government official to be forgiving to those people, because in most cases that does not happen due to various social factors. So how do we approach that from a more legal or say a regulatory framework? Do you have anything?
So Legal Aid Act came because of the judicial activism. Okay, Justice Bhagwati, you brought it in 87, that those who can't afford the justice system, state would support it. And all the crimes against women, it's a crime against state. So that would be, or any crime against Dalit or tribal, because we have entry at it is a crime against state. So the state takes a moral responsibility of using it. But the main problem is that because of lack of political will, the money is there, it is not utilized. There are states where there is 100% non-utilization. So we taxpayers have already paid for the legal aid, but it's not utilized. So that is one. Second route is a legislative route. You motivate the law, your people's representatives, whether they are incorporators or councillors or state legislators, state or parliamentarians. You have to motivate them and bring in the laws. For example, in Egypt, pita bread is provided free of charge by the state. Anywhere you can just, nobody will ask you for Aadhaar or anything. You just enter and you eat. Anyone who is hungry can eat. When Africa started soup kitchens, Nobody asks you for identity. You just enter the soup kitchens and eat, because that was the only way to address massive hunger in Africa. And that came because world leaders of 191 countries accepted goal number 1 as the eradication of hunger and poverty. So that politically also you have to take it up. It's both. Pass the law, because even what we got was a Sarva Shiksha Abhiyan, or right to food, or right to employment, MG Narega. There was once upon a time we also used to have food for work. That was suggestion of Dr. Amita Kumar Sen and Dr. Mehbubul Haq, Pakistani economist, whom Amita Kumar considered his guru. They were the ones who convinced the ILO that ask all nation states, because there is so much of hunger in the post-colonial countries, that give them wages because even if you have a paper money, the shopkeepers have their biases. No, they would not give. So it is better that the state takes response. You procure the grains, whatever basic necessities are there, you procure it, the state provides it in lieu of work. So that was also, there was a stage in the history of humankind where it had to be done. 60s, 70s, 80s, mass scale employment, food for work programs were started, because there was the hunger could not be addressed. Massive wastage used to happen. People used to throw, countries after countries, they used to throw their grain. Japan used to destroy its rice in the sea. America and Russia, they used to, not Russia, but America and Central Asia, they used to destroy this if there is a surplus. What is definition of surplus? Those who have not purchasing power. So if you don't have purchasing power, we'll destroy it. So that kind of thing. Then the environmental consciousness comes when you throw this thing in the land mines or in the sea, it also pollutes the sea. So much of organic material thrown in it. So then the new kind of thinking happened. So I think why do we do this research? To build the evidences that it is a cost effective not to charge. In fact, the very good study about charging for the health services, Shiva Kumar, you can read his article in APW, where he says that charging, the cost of charging for health services is higher. Social cost is higher than that of what state is spending. Okay, if you charge from a poor person, so this is based on the 56 African countries, where they say that the state spending so much on clerical staff, or the publishing so much of a material for receipt and all that, and monitor, and what will people do? If you charge from the poor people, they will stop coming to the hospital, and they will die of malnutrition, they will die of various type of the contagious disease, and that contagious disease will also affect so many other people. When HIV/AIDS happened, what happened? People did not have money. All the rich countries were charging so much royalty that it was unaffordable for any poor people. There are countries after countries where there were only elderly and children. Whole adult population had been wiped out in several African countries. So it was a major loss to the African countries. And then the lobbying happened that this patenting will not do. India took a lead, and we started providing affordable. In fact, there was a public interest litigation by Anand Grover against Novartis, no? And he won the case that you can't charge such a high prices for medicine, which is so important. It's a life and death of a person, and not only one person, for nations after nations, where HIV/AIDS was such a major thing. So there is in the final analysis, it is a politics in command. Politics in command. You have to take a political route also to build the public opinion against this. That's what Bangladesh did. What did they do? Dr. Zafarullah Chaudhry, why do we remember him? He's the one who came up with the Ganaswasthya, People's Health Movement. He says you can't, and he made a list of 200 medicines, told the Prime Minister of the country that these are the essential medicine which the state would provide at a no profit, no loss basis. Nobody will be allowed to profit over this. If you do cosmetic surgery, if you do this, then you charge. No, that is one. But for the essential medicine to address tuberculosis or diarrhea was a major killer in Bangladesh. And then they came up with a whole solution. Also, like that is a rehydration syrup, which anybody can make, clean water. pinch of salt. So there are various ways providing technological alternatives can be provided. There can be legal alternative provided. That can be politically convinced that the committee, like currently, why only Rajasthan has come up with so many, though there are so many adverse articles coming in the mainstream newspaper, that how can state afford to provide income support and 125 days of job under NREGA and also the health card and all that. But still, once they are convinced, politicians are convinced, then they pass it in the parliament or in the legislative assembly.
Yeah, and your question in terms of individual, psychology, obviously we can't change any particular judge or any particular prosecutor or anybody. But the thing is that I can take decision for myself as a person. So which side I want to stand? What are the choices which I want to make? Like as a lawyer, should I join those lawyers who are charging maybe crores and lakhs for one appearance, or should I become a pro bono lawyer? So again, it is a choice as an individual. I have a choice to make, and why a person make this kind of choices, that is all individual factors which are there. So again, we have to think about it, and how can we inculcate this kind of maybe something in upbringing or whatever, like so because in my family, if I see that okay, maybe my family is very conservative, very thing, but then why I joined this kind of social movements. I work with different organizations, and I saw different kind of people who are very different from the people in my family, and I thought maybe I have to make a choice. Okay, I don't want to be people who are sharing those WhatsApp group hate and other kind of things, or should I join those people who are really doing something for the country? So should I become like my inspiration, my inspiration should come from the social movements, or should it come from those groups which are spreading hate and whatever, polarizing the society? And so again, it's my choice, and that is what I think that we all have to make.
Yeah, even after making such choice, we are not starving. We are not being a middle class with multiple talents. You get your basic survival, and once your reference group also changes, there is no consumerism and there is no competition about food and this and that and status symbol and brand and all. And so your even cost of life also goes down, and still you are happy. It's not that you feel any kind of a deprivation. So these choices, making such choices, it is socially beneficial. It is beneficial to an individual because you get a sense of satisfaction, sense of fulfillment when there is called helper's high. There is a theory. When you help somebody, you always are highly spirited, no? So that also.
Thank you, ma'am. Moving on to the next question, Mr. Vivek.
Yeah.
Please ask the question.
Mr. Vivek, are you there? Yeah, he has raised question.
Ma'am,
Bolliye.
am I audible? Yeah.
Yes, sir. Yes, sir. You are audible. Yes. Please go ahead, sir.
Ma'am, my question is regarding submission of the research paper.
Yeah.
May I ask about? Yeah. So, ma'am, what will be the word limit? Submit that paper, research paper, and whether it is necessary to submit regarding.
Document that you are conducting the research. Huh? Hello, with the IMPRI's research, you mean?
Yes, ma'am. Hello.
This is a research report you will be preparing, no?
Yeah. Yes, ma'am. Yes, ma'am.
So that you decide, no? It is according to your number of samples you have, qualitative research. It is so.
Okay.
I don't think there is only for journal articles you have word limit. Here it is according to the scope of your research. No, it may be 20 page, 30 page, but it depends. we don't set the limit for that. It's a research report. When you convert it into article for publication, at that time, you will have to abide by the rules of that particular journal, whether it is 3,500 or 5,000. Now you currently focus on your research and write the report as per the structure that you have prepared, no, and the concept note and proposal that you have prepared. Go ahead.
Your voice is cracking. Can you?
Yeah,
What do you mean
Type the
is
question in
not
the chat box.
there? What do you mean it is not there, ma'am?
Word limit, there is right now, there is no word limit. You can write your report as much, in as much words you want. But then if you are sending it for publication to a journal or wherever,
Yes.
then we have to follow their guidelines. So for some journals, they say 3,000 word limit. Other journals say 5,000 word limit. So then we have to go by the word limit. But right now, depending on whatever the data you have collected, maybe you have collected some case studies, maybe you have talked to some people. So it all depends on how you are writing that and how you are presenting that. So that is about the word limit. Right now, there is no word limit.
Currently, you are at the stage of writing research report. After that, you can convert some research report. They convert it into 2 articles, no? One on field experiences, other one on case studies and this. But currently, you focus on your research. Because you'll have to follow that standard structure, no? Introduction, review of literature, research methodology, data, defining your universe from where you are collecting data, then your data collection, data analysis, summary, conclusion, recommendation, and ideas for further research. So whole report you will have to submit. Garvit, do you have a second question also? Because you have raised hand.
Meanwhile, I'll ask a question.
Yeah.
As we were speaking about free legal aid, so the people who most often require this legal aid are not available about the provisions or how to access it. So what steps are being taken by the government to increase the awareness of availing legal aid?
Yeah, if you see that Legal Service Authority Act in itself, it has built this component of legal literacy. So it is their job to really go, within the district, within the taluk or within the village to really go and spread awareness about the kind of schemes which are there. So it's there, one of the part of their responsibility that they should create awareness. But if they are not creating this awareness, then it becomes the civil society, the NGOs, the academic institutions, the law schools, then it becomes their responsibility, to spread this kind of education and awareness. So, that is what, because the government, again, it has, the things are there on the paper, but then if it is not being implemented, then who should monitor it? So basically it falls again upon to the civil society, these kind of different groups. So even as students, as citizens, they say, okay, as a citizen, I was talking to one of the, bureaucrat. I was doing the research on domestic violence. And then this person say, because you are creating awareness about, this domestic violence law, so we are getting more number of cases. So, this is the kind of response sometimes some people give. So it all, we have to see that, we are more concerned about, that justice should be available to all. We are not concerned that your cases are increasing. So you have to find the way and solutions to, reduce the number of cases. So, but people have to get justice. So this is what I think we have to, as civil society actors, we have to really play a role as citizens, as students, as, NGO members, as women's movement, as human rights movements. We have to really play this role.
And that is why Justice Verma committee said that any police, because each police station wants to have lowest number of crimes because that's what they want to show statistically. So most of the people, either they threaten them or they just beat them up and just throw them out, and they don't write FIR, because getting FIR written itself was a major task. So it is only after, even for Nirbhaya's case, you know, that they did not write, no, unless the agitation happened. And that's why Justice Verma committee also gave a recommendation, and Parliament of India also brought amendments in the Indian Evidence Act that you have to, when any person approaches the police, they have to write FIR. And now also there are police stations where people are beaten up and they don't write, but then they go to the NGOs and the social movements, democratic rights organization, which take up these cases, no? Like Manipur, also currently the national level agitation that's going on. Nothing was written. Even they were sexually molested in May, and this is July. And because nothing was happening, then the social movement and the people's movements, organization, women, all of them take it up.
Thank you, ma'am. If anyone else has any questions, Sulekha Das, please go ahead.
Hello. So my question is regarding to the research. So initially in the last session, I was suggested that I should, okay, first of all, my topic is challenges faced by Hindi medium students in higher education, case study of all 3 central universities in Delhi. So what I've done is I've interviewed students from both arts and social sciences stream. But when I received the letter, only social sciences is mentioned in that, the letter for the interview. So I just wanted to inform you, first of all, that it also includes art students, because I have interviewed students from departments of philosophy and psychology. And okay, secondly, my question is that in when we write our findings, there's information mentioned that you have to include box stories. So I'm not sure as to how to go about it, because most of the students that I've interviewed have been insistent on keeping their identities anonymous.
Correct.
So I'm not sure if I can take one student and include a box story, because that will endanger their position right now.
But you anonymize everything, no? You don't write the name of the university, you don't write name of the student or which class he or she is in. It is anonymized, no? You are only writing the story in a box without giving any antecedent of the person you have interviewed. Because otherwise, what's the use of qualitative research, no? You can't write in abstractions and generalizations. When you are doing research, you have to give specific details, no? So don't give the name of the village or surname, or even name also ABCD you can give. And also don't give which college or which university they are from. Okay. Because all 3 colleges are in Delhi. So this in my interview, the one respondent A, respondent C, respondent, that way you would say. You would not give even the name of college or university.
Yes, ma'am.
That is called anonymization. Yeah. And you must be having, see, a best way of anonymizing is to have a larger sample. If you have a 30, 40, 50 sample, then anonymization is much easier. As you know, Dr. Jesani told that when he did the analysis of 3 hospital case studies of auxiliary nurses and midwives in 3 districts, it was difficult to anonymize, because there were so many horror stories that these auxiliary nurses and midwives had shared about how they were bullied to bring population control, bullied to bring more this thing for sterilization operation, or they were threatened that if they don't get enough, they don't meet their target, they would lose their employment. Some of them reported about sexual harassment that they faced. All these stories he wrote, but then he demanded from the government that I will now give me 27 more districts. Then he increased his sample and interviewed auxiliary nurses, midwives of 30 districts, which took his 1 more year of work. But then he could anonymize that these were the patterns which were emerging, that what are the major mind-boggling problems, which auxiliary nurses and midwives, that out of 30 districts, in 21 districts, they were pressurized to bring more targets for sterilization operation. In 18 districts, there was no follow-up after the sterilization. In 12 districts, they inserted intrauterine device without their consent, or in they had to commute without any state transport. They had to walk for more than 10 to 12 kilometers, and on the way they were being harassed because every day they were going, so the predators knew. So anonymization became easier when the sample is larger. So if you are going to interview only 5 or 6 students, it won't be, anonymization will not be possible. But if you are interviewing, say, 20 students, 30 students, anonymization will be easy, because then they will not be able to get who said what to you. No?
Yes,
The other
ma'am.
thing is that when you're writing A has said this, B has said this. So maybe the last, like, after this paragraph, you can say, okay, the name of this person has been anonymized to protect his or her identity. So
Yeah,
you
because
have,
before the case study, you will have to define your university. These are 3 universities in Delhi. I have interviewed students at a postgraduate or undergraduate level in arts and social sciences. Okay, that data you will have to give, because that is the demographic profile of your sample you are giving. But if your sample is larger, anonymization will be easy. How many you have interviewed and how many you are going to interview?
Ma'am, a total of 25.
Then no
people,
problem. Very easy
Ma'am,
to
but
anonymize.
including all stakeholders, though, because there are teachers also, administrative staff also.
Yeah, so that you will have to divide. Student A said that, no? So, or one teacher say that. So teacher, student and staff, you will have to divide. But at least if you can take, say, 20 students, 10 teachers and 10 staff, anonymization will be easy for you. Total 40.
Okay, ma'am. Just one more doubt. So I got your point regarding the anonymization, and through their interviews, because I've already conducted 23, 24 interviews, I have divided whatever their major concerns were into categories while writing. And I've included their statements as an anonymous student said this and stuff, but I'm not sure how to include the box stories. If you could tell me something about
Box is that one, see, nature, what teacher will tell you will be very different, because they will be telling about the performance of the students in the class, or they will be concerned about their marks, or recently the IIT, today you read today's papers, IIT has said that nobody would ask how much you have scored in JEE and all. So teachers' concerns would be very different from that of a staff. Staff would talk about the discrimination at the time of admission, or ability to pay fees on time, or some of the other rules and regulations with the institution. And the students will be talking about their overall the ecosystem in the class, what kind of vibes they get from teachers and staff and fellow students, library facilities. So the nature of the problem, whichever you find the most representative of that section among the students cohort, which is the most representative, that particular thing you put in a box. Among teachers also, who is the most articulate, who is more focused in telling the challenges of the students, or even as a teacher, the teacher, that you put it in a box. And the staff will also talk to you about the administrative hassles that they face vis-a-vis students from different sociocultural background, that you put it in box. So 3 boxes you can have. If you think there is something about the student with multiple marginalities, that person is an underserved, poor, person with disability, or women who are from that category, then you can put 4th box also. Your box is something to highlight. See, because if your research is of 20 or 30 pages, anything which is in box will catch. That would catch. It would register. People would know that you have put it in box because it's a major highlight of your research.
you can go through your maybe whatever the answers, the responses which have been given. So go through them once again, and then you may come across if somebody has said something which is which is very different from others. So that also you can just say, okay, this is the kind of response which is something different from what other people have said. So these are the way you can think of working on your boxes.
Very sharp and hard hitting this thing, interviews that you can put it in box so that it conveys the message of your research.
Thank you,
Okay,
ma'am.
Thank you, ma'am.
Moving forward with the next session,
Yeah.
we have Professor Amita Singh, who will be taking up a session on the topic, the politics of law and deficits of implementation. Professor Amita Singh is the president of NAP-SIPAG Disaster Research Group, NDRG, and a retired professor from Jawaharlal Nehru University, New Delhi. Welcome, ma'am, and over to you.
Yeah, okay. So a very, very good afternoon, good morning, whatever, to all of you. Friends, I'm taking up a topic which is quite contemporary, and I want you all to relate with it because, there are very specific questions about the fact that I'm talking about the politics of law. And one would say that we bring law so that we can reduce politics. And on the contrary, the issue right now is that we are talking about the politics embedded within the framework of law. So if you put up the PowerPoint, which I have sent you, I think I would be in a better position to, yes, wonderful. So the politics of law. Now, how do we understand law? If we just say that, if I ask you what is law, how are you going to take it? Put it to the next slide. We understand it as a command of a sovereign. It's a sacrosanct command which is to be followed, which is to be abided by. It is a binding custom or a practice, which is going on for ages, like all these, laws of communities, religion, which, even if we despise religion, we still have them with us because they are very important. In some way, they are a binding custom for the community, and they are treated to be like they are there, and they are the survival practices of the community, also the subsistence existence that they provide to the community. Then they are formally recognized as binding, enforced by a controlling authority. Law is a law because it has a controlling authority. Everything else may not have a controlling authority. Your parents may say something to you, but if as long as they are not a controlling authority, you would not really agree to many of the things that are told to you. And the last part is that a law is a law because the court has the authority to interpret it and apply it and uphold it. Even, the administrative authorities may just fall apart and may not listen to what the citizens are saying if there is not this court. So we ultimately land up in the court saying that it's a law because we have the court to tell us and tell everyone that it's a law, and they have a right there as protectors of law. The second, just change to the next slide. Yeah, now we are coming to a very interesting part of it, that we said that it's a binding custom or a practice of a community. It's binding custom or practice, and that is considered to be a facilitator of law because it facilitates. If anything is not a custom, if a community doesn't believe in it, you can never have law. So we have law because some people really believe in it, and they cannot have a life other than what they believe in it. So it continues. So we have, the practice of, the communal laws in our constitution. Why are, the fathers of the constitution thought it best to have them there? Because the communities are at peace. They are thinking that they are part of the constitution, and they would continue in a very safe framework. The constitution, even though it's coming from UK, Ireland, or America, it is not really changing the basic framework within which they are standing. So it is a binding custom practice, and that's a facilitator of law. And that's how the constitution makers had put many of the laws of communities and customs and all into it. And we have like the 6th schedule with our constitution. We had many other areas in which the practices of carrying on with the local governance institutions as they were prior to independence was basically because of this belief. The second thing that we said was enforced by a controlling authority. So what is enforced by a controlling authority is law. So who enforces it? Obviously, the district magistrate would be the first person to enforce it. And from the district magistrate, we have the whole district authority, the whole pyramid of administration that controls it. We have, beyond that, we have the central cabinet, we have the constitution that has 3 frameworks, you know, of state laws and central laws and concurrent laws, the list, the 7th schedules. And then we have the court upholds and interpret. This is also a facilitator, that we believe in law, we abide by law because there are courts. Now I'll tell you the mischief which is embedded in all these 3 beliefs, that we think is law and we should abide by law because they exist for us. Now, how are we going to analyze this? Number 1, a binding custom or practice of a community. But all the communities, see, the whole political science framework, the modern political science framework is raised on something which is customary practices and communities and the local governance. The whole framework, you know, the whole edifice of, you know, the emperor's kingdom that takes you to prime minister and to the presidential system is actually raised on this. So how do we see this? It's a binding custom or practice of a community, but communities are lobbies, interest groups, and collective choices. And when you actually go down to vote, okay, start from the Bhagidari system, start from the RWA system. What is an RWA system? What is the Bhagidari system? We know, we are in Delhi, and we know that, you know, Sheila Dikshit had very encouragingly introduced the Bhagidari system. It worked very well for some time. And then the RWAs realized that, oh, this means that whoever controls the RWA controls the purse. And it's not just the purse, it goes beyond the purse because it gives you a position. And when it gives you a position, you have to fight an election. And then election becomes a fight of the lobbies. It is no community. You'll be surprised that when I wrote my paper for the Asian Development Bank in 2005 from Gurgaon, I was witnessing live the election process in Gurgaon. That election process was between 2 sarpanch, and they were not the party sarpanchas. Interestingly, one sarpanch represented the DLF and the other sarpanch represented the local village community. So now all the village communities melted into a village community, whether they were Gujars or whether they were Yadavs or any of the other communities that were there. Especially the Kumhars was a dominant community, but you know, everything melted into one. Their basic community differences melted down. But the other sarpanch represented DLF, and you'll find it ironical to note that the same DLF sarpanch exists still today. Through his wife, through his family, through other people, it is still controlling this ward where we are, a majority of us, which is a cyber city, which is the hub of the biggest revenue that Gurgaon provides to Chandigarh. Now, when the fight ensued, we were wondering, like political scientists, why this is happening, because the villages should be represented by this one, and they were at loggerheads with each other. It was because there was an act in the background that the Vidhan Sabha of Haryana was bringing about. The act was starting with stage 1, amend the Panchayati Raj Act. And they brought 3 major amendments into Panchayati Raj Act. And the first one was that 6 monthly meetings or third monthly, fact-finding survey, all that investigative understanding of all the participants is not required. So you can have one meeting in a year and then be okay with it. So that was the first. The second was that Up-Sarpancha's post was removed. And the third was that the jurisdictional issues were transferred to the district magistrate. So the panchayats weakened between 2005 and 2011. And in 2010, another amendment came within the same period. Why? Because the developers wanted somebody who could control the land and pass it on to the developers. So there are huge land, 58 villages in Gurgaon. And there was huge land. That land was being eyed by the developer. If they get this land, they'll make a lot of money, which will be transferred to the politics of the state. And then we'll have, all lived happily ever after. So this was the fact. And till then, see, between 2005 and 2010, there was no municipal corporation in Gurgaon. All the urban areas, the apartments, the swanky apartments, were part of the village areas. They were part of the panchayats. And how did they get to vote in the panchayats? Because the moment they got their flat, there was a card given to them by the DLF and other developers as well. I'm naming DLF because my study was on that. But other developers also, like RD City, Unitech and others, and they gave a card, which card was like the election card for them. And they voted. And in 2010, the Municipal Corporation Act came in on the pretext that there is a huge change of land use in the city. And CLU is law, change of land use law. But there was this whole politics behind this change of land use. If these grabbers had not parceled out land to DLF and other developers, there wouldn't have been a queue to bringing about a change of land use law and putting it part of the Municipal Corporation Act. So in 2011, there was the first election of the municipal corporation, and the same Sarpanch who was representing DLF was very gladly, made the Sarpanch of, the whole cyber city. And then the cyber city came up. These were open agricultural areas. There were the last pond, 116th pond that was being covered is where the Belvedere Tower comes up. And this whole cyber city continued from here to the sector road. There was no sector road. Sector road that you see in Gurgaon was an agricultural area, hundreds of acres. And that was all lobbied out to the developers and to Gurgaon Metropolitan Authority, which came up later. And now today, last month, an act has been passed that Gurgaon Metropolitan Authority will revive all the ponds. How can the Metropolitan Authority revive 326 ponds? Because all these ponds have builders' edifices over it. Their construction over it. And it is impossible to dig. So out of 325, there are just 6 that have been excavated, which are open areas, school areas, and some sports areas, and they have been opened. So NGT has given a notice to not just Gurgaon Authority, but to West Bengal and large number of other metropolitan authorities in the country to please excavate this, because the city is sinking in floods. This is the major cause of the floods. And then you have Disaster Management Authority, that is post-disaster politics of law, 2005 Act of Disaster Management Act, that you should do this, you should do that, form a supervisory team, have a plan, have the GIS structures intact. That is the second part of the politics, that is how you do the post-mortem of a dead body. So the politics of law. Now you know the binding custom practice of a community, where the community is divided by lobbies, interests. Now in Manipur, they were all, living peacefully. And I have a number of students coming from Manipur who got their PhDs from me in JNU, and I'm still connected to them. In fact, the first of the Paite community student was was given PhD by me, was supervised PhD by me. And the Paiti community came and they honored me because I gave them this. And this boy was standing on the road because he was looking for some money to shift his family to Mizoram. And that's where he somehow messaged to me, and we all rose up in Delhi, so how we can help them. So this is the situation of citizens where binding custom, practice, or community, there's something missing in law. We are missing out on the politics which is embedded in law. And I'll end up with that analysis, but we come to the second point right now. Enforced by a controlling authority. We believe that district magistrate and the whole police force is there to support us. We either believe in this, have faith in this, or we believe on the other side that they are all our enemies, right? So we are somewhere in midway, believe in this or believe in that. There is no midway that we believe in. But let's see what really exists on the ground. The control of authorities is dispersed. This is, obstruction in law. See this side, left side, where the green arrow is, facilitators of law, are the 3 points that we thought were facilitators of law. On the right side, the orange thing is that creates obstructions to law. So the second is controlling authority is dispersed. If somebody has a problem, the first thing we do is we rush to the police station and we tell them that, see, this is the problem. Some people landed up in my house and they were abusing this, pulling away things and my people and old people and all this insecurity. Police wala would first say that, have you got a photo? Have you got a video? Or I'm talking about the latest readings about the Cyber City, Gurgaon, Haryana area. I'm talking about the latest that exists. And you will realize that where you're living. And then the authority would, then this policeman would say, first of all, you will not be entertained because there are a large number of police officers. And I encountered one very recently. He said, it's not good for decent women to enter the police station. So which is the controlling authority? You are a single woman in the house, you have to go, your husband is not there, your parents, father, son, whatever men you can have are not there. So you have to rush to the police station, and there the police wala is becoming a sermonizing pundit to tell you, it's not really good, madam. Why do you stay alone? Don't you have a son? Oh, you have daughters. Okay, so daughters to paraya dhan hai. They'll start talking and wasting your time. Then finally, if you become tough, then they'll tell you, it's not really good for decent women to come. Anyway, you tell what is it, we'll ask a superior to register your complaint, but it's only when the superior tells us to register your complaint. Before that, we will not do that. And then the final thing is, Are mil mart ke kar lo koi, just talk to the other party, we'll call them, and you are here. Talk to them and just settle down this thing outside. Why do you want to go into litigation and FIR and complaint and all this thing? So then the thing is that you are the victim. You have suffered injuries. You have been that this is happening. This is the stripping out of the Domestic Violence Act. This is stripping out of all the acts that first for help, you rush to the police station. And you may be very lucky if you get a sensible ACP or the SHO in any police station. Then after that, maybe for economic reasons or for property cases, you go straight to the district magistrate. Very difficult to meet the district magistrate, but today we have the Twitter or something, so at least social media has enabled the district magistrate to meet everyone. At least in Gurgaon, district magistrates are meeting everyone. You just have to wait outside in a queue. But he would just transfer it. Okay, I'm transferring it to the DTP. DTP will handle it. And in the DTP office, it's a whole jungle of lobbies sitting over there. Before you even reach there, there is somebody else who's already reached there against you. So the whole process of controlling authority is the law is there. but it is so weak in front of these controlling agency. What is happening? What is happening to the Enforcement Directorate today, to the CBI, and to the Delhi Police today? And we know that whatever is happening is because the controlling authorities are controlling them from somewhere else. The legitimate controlling authorities are embedded in a litigation process in the courts. And courts take their own healthy, wealthy time to deliver a judgment, or they never deliver a judgment, they just pass an order that this be dismissed. The third factor that we think is a facilitator of law is courts uphold and interpret. But before the courts upheld and interpret, the government itself has a lot of statutory power through ordinances. And they have UAPA, they have Sedition Act, and they have a large number of other acts. What happened during the pandemic? During the pandemic, they enforced an act which was, of the 19th Century Act to get hold of people, the Epidemic Act that even the Britishers had abandoned. After the Spanish flu, this act was in fear brought up by the Britishers, but later even the Britishers dropped it, and our government discovered it and brought it back to control. And then we know that the plight of migrant labor, they were sprayed at the borders of Uttar Pradesh, they were sprayed with insecticide and pesticides, that they were the ones who were bringing in the infection. And the whole of this healthy city, the beautiful city, is made by them, but not a place to stay and keep them and treat them. This is what we realize, that it is not one India, that's definitely another India within this India, which is not treated properly under the constitutional acts that are enforced by the government. And courts did not do anything at that point. They came much later, when the trouble was almost, adjustable, livable. So the independence of courts. So why does this happen? You take up the legal education. We go down to the legal education. Who gets and who becomes the advocate? And if he becomes the advocate, I have traveled through, unfortunately, in the district courts, and very sad, after my retirement, I've gone through the district courts, and great sadness emerged, because there the law was only 20%. 80% was networking that was working at the district courts. And I say this with a lot of confidence, because a student of mine who was practicing in Allahabad High Court, she had faced a number of problems because she came from a particular community. And there in Gurgaon Court or Dwarka or other courts which are here, we see that certainly the judges are raising questions on the legitimacy or the cultural background of women lawyers. They are also in one way trying to, but it's not just the judges. Not just the judges, because I'm scared of criticizing the judges who are sitting there in the district courts, but the lawyers, the bar associations, the bar councils, when it's, they are represented by women lawyers on the other side, it's not just the law, it's also about how you move your body in the court. You may just stretch your body in the court so that, you hit a woman lawyer on the other side or the woman victim on the other side, just to demoralize the person so that she gets discouraged from coming to the court, because the court ultimately belongs to the men folk. There is men folk, rich folk, the networks. And the judges sometimes get so scared because the lawyers are really unruly and unbridled, especially the bar associations of most of the district courts. That judges, the new judges, the junior judges are also so scared sometimes, they would just close the issue down as it is produced by, they won't use their mind. It's the network. Acha sahab, aap aaye hain? Acha bataiye, kya laaye? Ab ki baar kya laaye aap court mein? So that's how the conversation begins. It's not my lord, or you go to the court and then you find, what are these networks doing over there. So we know at the higher judiciary, the conflict between the collegium and the law ministry has been existing. We know that advocates on record cases have tremendously supported the collegium, and the law ministry has consistently supported that there must be a government person sitting over there. The truth is somewhere in between. Definitely, we want the independence of courts, but now imagine who is sitting in the court, high court, say, for example. They are the people who are sitting with definite lobbies, ideological lobbies as lawyers for 10, 15 years. And then they are nominated to be the judge in the high court. How can you expect that when they are faced with a lawyer who's coming from the same battalion, they would say no to it? And there have been umpteen number of cases in the past few years when the judges say what their ideological background is actually pushing them to say. See, judges are always ideologically driven, and there's no harm about it if they are ideologically driven, because all of us are driven. To some extent, it is always acceptable to be ideologically driven. It's a matter of human existence that we have our independent mind, which is leaning on one side or the other side. The problem comes in when you are completely controlled by an ideology, even though you are sitting in a seat of justice delivery. That is where the problem comes in. And so the whole constitution is laid to rest. And I'm so glad there is a judgment today, very important judgment. What was happening was largely in the High Court that even at the stage when the trial courts, the lower courts sometimes are having some very important judges also. So the trial court says that evidence is to be produced. Immediately, the respondent rushes to the High Court. When they rush to the High Court, they say that, oh, the 65B certificate was not given because, we have the Information Technology Act, and under that 65B certificate is to be produced for the evidence. Keeping the mind closed, the judges sometimes just say, oh yeah, the 65B certificate is not given, so the case is dismissed, right? Now the poor judge sitting in the trial court is only asking for production of evidence. Once the evidence comes in, only then one can make out whether this evidence needs 65B certificate to be electronic evidence or it just needs nothing. So let the evidence be brought forward. And today there is a wonderful judgment by the Supreme Court that, because it also shows that this was arbitrarily happening in the High Court in the last few years, that most of these cases were being dropped completely before the evidence could be produced. So a large number of people who were flexing their muscles on ideological grounds in the judiciary, in the High Court, will now get a good standing, because the Supreme Court has clearly said, and a very good bench has said that before the evidence could be produced, you cannot dismiss a case. So now the trial would go on, at least some politics would be reduced. When the trial would go on, doodh ka doodh, pani ka pani, the clarity would come in the court. Both the sides would get a chance. Audi alterum partem, the fundamental principle of law that everyone should get a hearing, they will get a hearing. So this is something that could be done. While we strengthen the court and talk about independence of the courts, we should not just focus on collegium and law ministry conflict, the appointment of judges. Of course, they are important. We need to balance that. But beyond that, a change of law in the procedural law need to be brought in so that the politics could be reduced. Next slide. Yeah, so now we've seen that district administration and panchayats are enforcement agencies. Now, we agree to there being an enforcement agency because this is what we know. Every citizen is focusing on this. And when every citizen focuses on this, then they need to have the police, the concerned ministry, and the district authorities. Now, have you noticed that in with the coming of liberalization, 95 onwards in 2005, but in cities where the city metropolitan authorities have come in, like Gurgaon Metropolitan Authority, Bangalore Metropolitan Authority, and Kolkata and other. Why have these metropolitan authorities come up? Because we have town and country planner position, a very powerful position. But that position became so powerful that that had to be controlled, because dispersal of authority is so rampant post-liberalization that agencyfication of governance started taking place. Lots of agencies came up. The district, town and country planner, like Haryana State Land Development Authority, Haryana State Industrial Development Authority. Similarly, everywhere else also, Udyog Vihars have come up in every metropolitan authority. And then the conflict comes in about the land, about the panchayats, about the change of land use, and about who gets the final cake. And this is, I have put it in a funnel, because these three are completely controlled. If we believe that they are independent, they are not. They are not even constitutionally driven. They are driven by the ruling party in power in the state. Next slide. Okay, so law is under siege. How is the law under siege? Because on one side, government regulatory agencies, including the judiciary, is controlling the law. And on the other side, we have the legitimate statutory powers, the acts which keep coming up. You know, this Forest Act, which has come up 3 days ago, there are thousands of people sitting and saying that these changes have to be brought up. The best process would have been that the government should have looked back. Otherwise, why do you ask? If you ask, then bring changes and have a discussion on that. It is illegitimate to ask people that give your opinion and then do not incorporate it. And without a single amendment, you just dump it on the country. This is the Forest Act which has come up. And this is a devastating time for the country, where so much is going to go away from the country. And this is and at a time when humanity is in the last gasp of its breath. One more breath and you collapse, because it's drowning, sea level rise, climate change, disasters. What else do you want, government? It is this. And we don't have the power to stop it. And at this point, I would stop, because I just wanted to let people know that they need a critical thinking about law, because law is not enough. Because we have a legislature where the opposition keeps shouting, and the ruling party keeps on passing. There are more than 500 laws passed across in the field of finance, in the field of ecosystem, ecology, forest, humanity, and that's democracy. And so in the end, what I say, last slide, the end of theoretical democracy. That's it. Okay.
Thank you so much, ma'am, for the enlightening session. I request Professor Vibhuti, ma'am, to share her remarks.
Yeah. Yes, Professor Amita Singh, for extremely powerful lecture. But my major question is that in a majoritarian democracy, what alternative do we have to see to it that whatever challenges we are facing currently, that more than 500 laws have been passed, and they are passed so hurriedly without public debate. And I think so many of our friends who were very optimistic and active in the social movement, they are quitting India, they are leaving. And
275,000 have quit India this year. It's a phenomenal rise. See the report. Oh,
Yeah.
God, it was terrible.
Yeah. So that kind of like that nation building, that the dream that people had, like they are now relocating themselves to other place just out of frustration.
See, the answer is only as simple as providing compulsory education to everyone. I still have every day to see hundreds of children picking up rags, bottles and waste, And even it is Swachh Bharat, but there is no Swachh Bharat around this cyber city, the fancy swanky office. There is no Swachh Bharat. Garbage people who are picking up garbage do not even have gumboots, and they are sinking into the monsoon, stinking, disease-ridden garbage. They don't have gloves. They are picking it through their hands. They don't have adequate machines. They don't have a garbage place. And on the other side, these big restaurateurs who are there, they are throwing their garbage. There's nobody who's slapping notices upon them. Interestingly, we see the leaning government on which side? On the side of this business, not on the side of these poor people, the caste ostracized people. There's nobody to hear them today. And education, we should be having a government that forces their children to go. Something I liked with the Punjab government recently, I heard that there was an advertisement in which the chief minister said that घर की चिंता नहीं होगी, तुम sports करो, घर की हम देखभाल करेंगे तुम्हारी. So can the government tell these rag pickers that, we'll take care of your children. Children don't have to worry about their home because we will take care of your home. Only then can the children study. Compulsory education till BA level is required. Compulsory food giving to these poor people and employment is required. For that, you have to immediately revive MSMEs. Almost 80% of the MSMEs where these unorganized labor had something to look forward to, they are closed. They are not reviving, and the disasters have closed many compulsorily. After the Tamil Nadu floods, governments tried to support them, and even after the support, only 15% returned. That goes on record. So where are these poor people going to go? And that's a cash economy. If you digitize economy, they will never have an employment. You have to have a cash economy. There must be a balancing of this cash economy because we have illiterate people. Even in an educated village outside this Gadi Harsaru, recent survey during this Delhi floods, because we wanted to collect fodder from there, dry fodder, and we called up this person who's fairly rich and his family is educated. They didn't have Paytm. They said, and we said, we can't come to your village. We are sending Paytm. He didn't have Paytm. The whole village didn't have Paytm. So what do you do? And there we have been living in, emperor's chambers.
And I think caste system very important because even when you had even enough funds in Sarva Shiksha Abhiyan Kitty, why don't they use it? Why, if there is a funds in Nirbhaya, why aren't they using it? It's basically a purgatory. I remember people like when we go for the training of IAS officers, they say, ma'am, if we start having Swadhar home, women will start running away. The system of family, structure of family will collapse. No, if this is what IAS officers think, then what do you? When you talk about the PCP and DT Act, they, instead of understanding the whole issue, they would say, ma'am, how many children do you have? I said, okay, daughter. They said, that's why you are jealous of others having son. If this is the kind of wavelength in which you are talking to the people with so much of power, if then where do we go? So it is not only education, but even the values that these educated
values,
people
have. I'll just end up with this. Besides this is a standard problem of education which need urgent emergency handling. And there must be no backlash on this. We have to be thoroughly prepared. It's a disaster we are creating within the country. And we will then continue to get governments. And then we'll continue to shout, that we are getting this government. We are going to get governments which are uneducated, which are not exposed, which are ideologically and religiously driven. We will get it because religion is a abode of a very poor person. And so we'll continue to get those governments. So if we want, we need to be handling it with emergency. But there is also something that I need to share with you. There were a large number of basic effort of the previous government that was done in very, very backward areas. And it was picking up. Like we surveyed 400 best practices of communities in between 2010 to 2012. From Bundelkhand, from the very backward areas, Bundelkhand and Barashat areas in West Bengal, or tea garden areas, and then in the Himachal area, there were selected areas where we did the study. And those women were coming forward, and the husbands who were very patriarchal earlier and caste-driven were no more caste-driven. The Brahmin families were coming forward to educate these poor people because they realized that, and that was, I'm telling you, in Orcha. And the General Assembly even called us to present this study in UNESCO in New York. And it was a very interesting thing. Like Sheila Dikshit, she divided Delhi into about 85 units under the program Mission Convergence. It was a phenomenal program, Mission Convergence. And Mission Convergence means that the person, the community person would be sitting over there. So one-to-one, so that reduces the lobbies. When the person is there one-to-one, it reduces the lobbies because people would go to the person who's giving them something. So you have to give. So it can't be just politics. You have to give. They want SC/ST certificate. They want driving license. They want medical support, like Mohalla clinics, which are running right now by our government. There's something, a predecessor was this, the previous Mission Convergence. And that is what that brought Sheila Dikshit to the third term. So some of these efforts are really required by the politicians to talk no religion, nothing else, just services to people. And let's see how many governments can win the election after that.
Yeah, very important.
So
At the state level, at the subnational level, you see such things happening. That is one which is very optimistic. We saw in Karnataka also, where the local politics played a very important.
It will happen in Kerala also. Kudumbashree will ultimately be.
Yeah. And even in the disaster, their performance was the best. Good. Thank you. Extremely.
Thank you. Okay. Thank you very much.
Shalu ma'am,
Thank you, all of you. Thank you.
Yeah.
I request Shalu ma'am to share her remarks as well.
Thank you, ma'am. I think she is on. Thank you for a wonderful presentation, but they require a lot of things to be done, because even if we talk about education, when I stay in Gurgaon, and the kind of things which are going on, because in March we have this Resident Welfare Association meeting, and in this meeting they presented their the budget, and what they say is that we have to give money to the government officials, because one of the like the fire building inspector, he came in, and we have to give him kind of some black money, because our certificates were not up to the mark. So it's talking that education, that the kind of educated people, and we are not talking about that kind of taking action against this corruption, though we all are being affected by it, but some people are not taking action, others are not, so in that kind of situations, I think we need to talk about the change in education curriculums, to telling you how to politicize, how to raise your issues. So maybe that kind of thing, I think that is more important.
Hello, ma'am is there.
Ma'am has left, so
Yeah. But she must be having class, no, at 1:30. Yeah. Okay.
I request the Chair, Professor Vibhuti, to share her closing remarks.
Yeah, I think today we had a very important issues, which are extremely important from the point of view of common person, how to access the legal services, how to access the whatever policy imperatives that we have. And I think for that, the two case studies, one of Legal Aid Services Act, and how what is the state of the art in this area. Dr. Singh's, Professor Singh's presentation was also very important, because currently the challenges that we are facing in terms of a status quo or a policy paralysis, or so many hurriedly brought in laws without any democratic processes, without any discussion, and constant disruption of parliament because of this kind of absence of dialogue and complete centralization, because the move over last 5 years has been total centralization, while what we need is a more and more democratic decentralization. And wherever there is a democratic decentralization, it is easier to both democratic decentralization coupled with people's participation in decision-making process, then we get the very good results. And I think that has been the experience of several post-colonial countries. If you see whether it is a Southeast Asian countries or East Asian countries, or in several African countries, Latino countries, all of them have shown, the experiences have shown that decentralization coupled with people's participation is the answer. So for the good governance, no? So I think these are some of the learnings, and major challenge that we are facing is that so many sensible people were highly qualified people who once upon a time wanted to contribute their best to the nation building. They are quitting our country. There you must be reading also articles that people are just leaving India. People, professionally competent people, they are leaving India because of the anarchy, collapse of governance, policy paralysis, and the muscle power, mafia power, and money power that rules the roost. No, so that and we are facing. This is the majoritarian democracy has brought in, and a lot of rethinking is going on. We go back to the first lecture by Mr. Sandeep Chachra, where he'll also say that when there is a majoritarian democracy, then the minorities, all those, and we know that intersectional vulnerabilities are so many. So you are totally insensitive to those intersectional vulnerabilities, and those who are religious minority, sexual minority, people with disability, minority because of their situation of poverty or situation of illiteracy, that they are left out of the integration into the development process. So we need to come up with an alternative, and that alternative is only of people's participation and evidence-based action research that feeds into the policy, so that we target our efforts, developmental efforts, national resources in a right direction. Thank you.
Thank you, ma'am. With the chair's permission, we can go for the vote of thanks. As we come to the end of day 22 of Law and Public Policy Youth
Go ahead.
Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course and internship program, I, Nikita Bhardwaj, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our experts for the day 22 session, Advocate Dr. Shalu Nigam and Professor Amita Singh, for taking out their valuable time and giving us an opportunity to learn from this online certificate program. We thank our chair, Professor Vibhuti Patel, and lead advisor, Advocate Dr. Shalu Nigam, for convening the session. We thank all of our participants who have raised pertinent questions and actively participated in today's deliberation. We look forward to welcoming you coming Wednesday, that is 2nd August at 11:30 a.m. for our day 23 of this certification course by distinguished experts, Dr. Ajay Gudavarti and Sri Amit Dubey. We are grateful if you are watching us later on YouTube or listening to us on our various podcasts or reading our publications. We hope you continue to join in future to IMPRI, #Web Policy Talk and #Web Policy Learning. Wishing you a good day. Thank you.